Welcome back to News Now from Fox, everybody. Almost 7:35 a.m. here on the East Coast, 6:35 a.m. there in Minneapolis, Minnesota, where you are taking a live look over right now. A absolutely gorgeous sunrise over the Twin City. And as you know, all eyes have been on Minneapolis as the trial for Derek Chauvin, the former Minneapolis police officer accused of killing George Floyd last Memorial Day, was underway in its first week this week, with jury selection beginning. And most recently, breaking news yesterday, a third-degree murder charge now reinstated in the trial. So what exactly does that mean? Well, joining me right now is Minneapolis criminal defense lawyer Ryan Pacyga. Ryan, good morning to you. Thank you so much for joining us again here on News Now from Fox.
Good morning. Thanks for having me.
Well, we have a lot of ground to cover related to this trial. It's been a very long week with jury selection, and now yesterday specifically, a third-degree murder charge, was reinstated. So what exactly does that mean?
Well, in Minnesota, we've got this law that is very muddy. Our third-degree murder statute hasn't been used frequently for cop killings whatsoever, and the law in itself is muddy. And what happened is when the Noor decision came out, that muddied the water even more. So what our law says is whoever, without the intent to make somebody die, perpetrates an act eminently dangerous to others and evincing a depraved mind without regard for human life is guilty of third-degree murder. The problem with that law is that the legislature who makes our laws never defined what depraved mind is. And the issue in the Noor decision that everybody's grappling with now is, does dangerous to others mean one person, or does it mean multiple people? And what we had happen is when this Noor decision got sent back down to the Chauvin trial, the Court of Appeals here said, Judge Cahill, you've got to make a decision consistent with our new holding in the Noor case. The new holding, which really turned on its head our basic understanding of third-degree murder for most criminal law practitioners, is that it said others can be targeted at one person. And that's the issue now. And so Judge Cahill felt constrained by that court opinion, knowing that he had to make his rulings within the bounds of that new court opinion. And even if he personally disagrees with the interpretation of that law, that is the state of the current law in Minnesota, unless and until our Minnesota Supreme Court reverses that Noor decision.
Yeah, Mr. Pacyga, we are actually currently taking a look at some video from the courtroom yesterday. So what did the lawyers kind of say to Judge Cahill? How did this reinstatement even officially be declared?
Yeah, so when the Court of Appeals made its ruling in Noor, that ruling was appealed to the Minnesota Supreme Court, who granted review, which is a big sign to us lawyers that it's sort of like waters down the precedential value, because now that means the Supreme Court could reverse it. If they didn't grant review, that would have become the final law in Minnesota. So once that happened, the prosecutors seized on that, though, and they said, aha, Judge, you've got to make a ruling now that's consistent with this. This is precedential. What the defense lawyer did is what a defense lawyer would have to do in that situation, and that is try to distinguish the facts of this case from the Noor case. In the Noor case, the officer was in his squad car. He got startled. He reached across his partner and shot and hit one of the people who were calling law enforcement, kind of a pedestrian, if you will. And there were other people moving about in the neighborhood. So theoretically, it could have endangered not only her, who he killed, but anybody else that was in their homes within gunfire, if he would have missed, or people walking by and so forth. So the defense lawyer said, well, this is much different. Here, Chauvin had his knee directly on Floyd's neck. He's not endangering anybody else around him. He couldn't endanger anybody else around him. And for that reason alone, these facts are different. And so, Judge, you can still rule and say these facts are much different. It didn't endanger anybody else. And so you should distinguish this and not reinstate the third-degree charge. The prosecutor says, aha, but the Court of Appeals in that new Noor decision said that we have this singular person rule, meaning that even if your act is only targeted at a single person, that still counts for third-degree murder in Minnesota. And that will be the big issue that the Supreme Court is going to have to weigh in on this Noor decision, but we're not going to have that decision until probably sometime between October and December. In the meantime, we've got this very muddy law, this big question about whether an act can be targeted at a single person or not. And because that's the state of the law right now, at least temporarily, that's why the judge reinstated it.
And Mr. Pacyga, yesterday a sixth juror was selected for the trial. Now, there was a lot of questions surrounding the selection because jurors are obviously not supposed to have any emotional attachment to a case, but this is such a high-profile case. So what can you say about the jurors that have been questioned, and has this been an easy process for attorneys?
Well, yeah, you're right. So a lot of jurors have noticed the courthouse security that we've never had with these barbed wire fences around our courthouse. They've taught everybody and their mother around here knows about the case, probably across the nation. And so there are those heightened concerns. Some jurors have said they feel better about the security that's around the courthouse. Others are realizing just the gravity of this case if they haven't thought about it much before. So what we don't typically see is that many jurors in a case knowing in advance what's really coming in the case. Most people have seen this video. Most people have had a reaction to it. So that is not common for a criminal trial. The other concerns that we're seeing are indeed common. Can I be fair? Do I have concerns about the length of a trial? Do I have concerns about how others might react to a verdict I make or not? Those are some things that we see. So this is typical, other than the pretrial exposure that jurors have had. I was always surprised that we were going to keep the trial here in Hennepin County because this is ground zero for where it happened. And I guess ideally you'd think that the further you get away from here, the more chance there is that jurors either aren't as aware of it or at least didn't go down to the site where this happened. A lot of people in the city have gone right down to where this act occurred on 38th Street in South Minneapolis. And so it really hits close to home for people. But jurors have been able to say that, at least in their opinion, they're going to be able to set this aside to the best that they can and wait to render judgment until all the facts come in the trial.
Mr. Pacyga, what exactly can we expect in the courtroom today? Week one is about to wrap up, and when will this trial officially get underway? What can we expect in the weeks moving forward as well?
Well, I think you're going to continue to see some more motions in limine. That's where they continue to set the ground rules for the trials, and this happens outside of the presence of prospective jurors. So things like, what about this idea of evidence? Can we get this in or not? If so, are you going to limit how much of it comes in, judge, or not? That continues on during jury selection to be efficient. They have the lawyers come before for that. And then the other part we're going to see is we're going to continue to see jury selection. Now, a couple times in this case, the prosecution has accused the defense of having race-based strikes. They did that on the first day, and they did it again yesterday. Judge Cahill said, listen, we've got a diverse jury. It's about 50-50 in terms of persons of color versus Caucasians. So he's telling the prosecution twice, I'm not seeing any evidence of race-based strikes. I think you're still going to hear some chirping about that from the prosecution from time to time because they're going to want to make sure the judge is uber aware of that and watching for that. And in addition to that, you're going to have situations where we're still going to see some jurors who say, I can't get past this. Despite my best efforts, I'm not good for this. And they'll be struck for cause. And then you're going to see this wrangling about the lawyers trying to undo what a juror says so that they make the other side use one of these precious peremptory strikes that were each allocated. Once you're out of these peremptory strikes that you're allocated, think of them like arrows in a quiver. Once you're out of them, you're out of them. And any other jurors that come up have to be sat unless the other side strikes them.
All right, well, Minneapolis defense attorney Ryan Pacyga, there has been a lot of information coming out of this trial all week, so we really appreciate you joining us here on News Now from Fox to break it all down for our viewers.
Happy to help and have a great weekend.
Yes, you have a great weekend as well. Taking another live look over the Twin City, we're going to send some of you on a 2-minute commercial break. More News Now from Fox is coming up right after that.